Lordship, may I complete with only one submission? I do not ever wish to give the bench, which I know is preoccupied with so many matters, but if you have only 20 minutes over this weekend, log into the Bombay Bar Association. The most respected person today in India, Mr. Dastur, has given a podcast on what will happen with this act on the tribunal. If your lordships has just 15 minutes, I bear with me and see it. I close with that.
We will be, if we do that, we will be alleged that we are referring to an material which is not put to the other side.
But I'm asking the learned Attorney General, this is not an adversarial litigation. I'm requesting him to see it also. I'm requesting the AG to see it also. I'm grateful, Your Lordship.
How many broadcasts have been done so far now?
Your Lordship, there are many being done. There are many, I think about 8 to 10 have been done, and they have been a tremendous hit. So I'm grateful to the Bar Association because we are fortunate to have the wisdom of so many of these seniors saved for posterity.
Thank you.
I'm obliged.
I suspect the day is not far away when my Lord, the Chief Justice, will also be a part of that podcast.
I'm in the waiting list, number one.
You're waiting list. I had a feeling.
I've been already told by Mr. Nitin Thakkar that in my next visit to Mumbai.
We'll all look forward to it. Vinod, if you just see the indexed.
Post it on your 10th.
It is most people.
On 10th.
As yourself.
My Lord.
One more mentioning, if my lords would permit, my lord, your lordship will recollect that NGT matter, my lord, your lordships, my lord, the AG had sought instructions till 2 p.m. my lord.
No, but then we have taken all the fresh matters, Mr. Mishra. All urgent matters we took in the morning.
No, your lordship, this some matter.
After notice.
Please, your lordship.
Lords, may I mention item 35?
Mentioning for the date. Item 19, my lord, may have it after 2 weeks. I need to file that.
Lords, may I mention item 35, my lords? This is the Goa medical admission matter. Your lordships had restrained us from filling up one seat. The petitioner has already obtained admission in the All India quota. My stay round begins today, my lords. I need your lordship's permission to fill up that seat now.
Which was
Lords, I've given notice to Karanjawala and company.
But I appeal for the intervener, my lord. I am next in the merit list, my lord.
Would your lordships take it up at the end of the day? I will give notice again.
When is the straight round coming to an end?
Lords, it comes to an end on the 14th, I believe.
Maybe have it on Monday, my lord.
Monday, would your lordships consider?
We had received
My Lord, item 40, my Lord.
mentioned at the end. We had received a mail that the
Yes, yes.
mentioned at
Then-
4 p.m.
My learned friend is right. We first sent. Anyway, your lordships are taking it up on Monday. We don't need to.
My Lord, Union of India had sought time before lunch session to seek instructions in that NGT matter, extension of expert members who are
Get the
retiring.
matter called out.
Your Lordship, may I mention item 30? I am seeking indulgence for 2
Four-
days.
40.
30.
What do you want?
Indulgence for today, Your Lordship, anytime next.
No, today no.
No, I don't want it to be heard today. Let it be heard at any day next week, Your Lordship.
Who is your opponent?
Lord, I am appealing for the petitioners, my lord. There is some urgency. That's why Lord, so fixed today, my lord. Lord, may have it on Tuesday, my lord, high up on the board, my lord. 15th is the last date of admission, my lord. So after notice matter completion.
Tuesday we are going to take PM Gudon.
Monday hearing for other.
Monday, high up on the board, my lord. There is some urgency, my lord.
Monday we want to finish this one.
That's why I have requested for Tuesday. Tuesday, high up on the board, my lord, I request, my lord.
Tuesday we are
Item 30.
Lord, so you are fixing for Wednesday. Lord, so you are fixing it for?
Wednesday we have MC Meza.
15th is the last date of admission. That's the difficulty, my lord. Readings are completed. On Monday, my lord. I'm grateful.
Lord, it was item 40, my lord, your lordship will recollect. The AG had sought time till 2 o'clock, my lord, before the seek instruction.
Lordship, the NGT member retires on 13th. The AG will make some submission on Monday regarding this.
Is anybody retiring till Monday?
No.
No, 13th is the date, my lord. After that, the bench
13th.
cannot sit in the absence of the expert member, my lord.
And they'll have.
By
to-
Monday, something will be sorted out.
All right.
Very well. Grateful.
Well, it's only one aspect on the wiries of the Act remains, which is the proviso to Section 5. And my lords had asked me to file the consolidated compilation. We have filed that. My lords will find my submissions from page 19 onwards in the compilation. Now that provision is at page 19. Would my lords just see that for a moment? And I'll show just one judgment because I've already addressed my lords on both Justice Bhatt's finding on this and Justice Rao's finding on this. Page 19. This is the proviso to Section 5, which provides for a 4-year tenure. Now, to the left is the proviso that was before the court in MBA 4. Do my lords have page 19 of? That is the case law compilation, my lords. The compilation given today by Mr.
Yes, we have the same thing.
My lord, just page 19.
Proviso to section 184 and proviso
The
to
provision on
section
the left is the provision which was there before MBA 4, which said that notwithstanding your terms of appointment, you will now be curtailed to 4 years. This was considered by my lords in MBA 4, and the argument of validating legislation was taken there also because Section 5 starts with a validating clause. And my lords relied on a judgment, which I would like to show, my lords, which is in the case law compilation, which is the first judgment, Virendra Singh Huda. Because one exception to removal of the basis by Parliament is that if by a judicial order a benefit is given to a litigant, even if the basis of the judgment is removed, that benefit cannot be taken back. May I just show that, my lords? Is the first judgment in the judgment compilation.
Yes.
If my lords come to page 33, paragraph 68. May I read?
Yes.
Despite this, so after discussing the power of Parliament to take away the basis, this is what my lords held in Huda. Despite the aforesaid conclusion, the Act, that is the proviso to Section 4.3, to the extent that it takes away the appointments already made, some of the petitioners had been appointed much before the enforcement of the Act, 10 in numbers, notice here and above, in implementation of this court's decision would be unreasonable, harsh, arbitrary, and violative of 14. The law does not permit the legislature to take back what has been granted in implementation of the court's decision. Such a course is impermissible. Then if my lords would come to page 36 for the conclusions in that case. Only one conclusion is relevant, which is conclusion number 3 at page 36. If I may read my.
Yes.
The first proviso to Section 4.3, to the limited extent it provides for dispensing the services of candidates already appointed, is harsh, excessive, arbitrary, violative of Article 14 of the Constitution. The benefits already granted to the petitioners in writ petition number so and so and so and so could not be taken back. To this extent, retrospectivity is ultra wise. Now, if my lords will see MBA 4, only 2 paragraphs I'll show again, my lords. If my lords have page 457 in the same compilation, MBA 4 is in the same compilation. Yes.
1 minute. Court discharge.
Page 457. This is Justice Rao's conclusion in MBA 4.
Page?
457 of this compilation. Paragraph 65.
Yes.
May I read my notes? Insofar as the proviso to section 184(11), and that's precisely the same proviso in the present act, the ordinance sets the maximum tenure at 5 years, even with respect to the appointment orders passed between 26/5/2017 and 4/4/2021, provided for a higher tenure. In the process, interim directions given by this court in Kudrat Sandhu are also nullified. It would be relevant to refer to the directions issued by this court in Kudrat Sandhu on 9/2/2018, after taking the consent of the learned Attorney General and making modifications incorporating his suggestions. This court held that all selections to the post of chairperson, chairman, judicial, administrative members shall be for a period as provided in the Act and the rules in respect of all tribunals. On 16/7/18, this court directed that persons selected as members of ITAT can continue till the age of 62 years and persons who are holding the post of president till 65 years. By an order dated 21/8/18, this court clarified that a person selected as a member CSTAT shall continue till the age of 62 years, while a person holding the post of president can continue till the age of 65. Though there is nothing wrong with the proviso to section 184(11) being given retrospective effect, the appointments made pursuant to the interim directions passed by this court cannot be interfered with. This court in Virendra Huda upheld the retrospectivity of the legislation which had been challenged, but the appointment of the petitioners therein pursuant to a direction of the court was saved. It was held that the law does not permit the legislature to take back what has been granted in the implementation of the court's directions, and such a course is impermissible. Similarly, in S.R. Bhagwat, it was declared that a mandamus against the respondent state giving financial benefits to the petitioners therein cannot be nullified by legislation. It is also relevant to point out that even interim orders passed by this court cannot be overruled by a legislative act as discussed above. Now comes the conclusion. While making it clear that the appointments that are made to CSTAT on the basis of interim orders passed by this court shall be governed by the relevant statute and the rules framed thereunder as they existed prior to the Finance Act 2017, we uphold the retrospectivity given to the proviso to section 184(11). To clarify further, all appointments after 4/4/21 shall be governed by the ordinance as modified with the directions contained therein. Now, one would have expected after this finding that the act, when the ordinance becomes the act, there would have been an exception carved out for the CSTAT members that are mentioned here, but nothing was done. Interestingly, this validating clause was there in the ordinance as well. And if I can show one paragraph of Justice Bhatt's opinion, page 485, which would be equally applicable even today. Page 485, para 116. Because it is my contention that this proviso is in the nature of a one-man legislation. It's a proviso added only to curtail the tenure of the 4 persons who have been appointed to the CSTAT and are to retire till the age of 62. Yes, as it is called in England, the Bill of Attainder. It is called the Bill of Attainder. That is a legislation that effectively declares.
Effectively declares what?
Effectively declares and nullifies a judicial decision without more. So Justice Bhatt relies upon the judgment of P. Venugopal, who was the director of AIMS, whose tenure was sought to be similarly curtailed. Though there it was a 1 person and it was called a one-man legislation. In my submission, this is a 4-person legislation. This proviso to 5 only affects, that is 2 persons. So there it was 2 persons, here we are 4 persons.
2 by 2.
If I
the 21 in the ITAT.
That may have to be seen because the judgment expressly refers to the CSTAT members. When the judgment expressly refers to...
They are also appointed under the old statute.
Your Lordship,
The different analogy would apply to them.
yes, Your Lordship, I will deal with that when my argument's turn comes, if Your Lordship.
In the CSTAT order follows the ITAT order in Kudrat Sandhu.
Yes, that's true.
The CSTAT gets relieved, but ITAT members was left with it.
In fact, Lord, if I may just supplement, Lord, for when Your Lordship looks at the list, CSTAT members are here not from 1.2 onwards, and their position is that they ought to be covered under the old rules and the old regime. Despite an order of your Lordship's Court of 21st August 2018 of a 3-judges bench, they're still not proceeding to act.
They're not still?
They're still not proceeding to recognize that we should be covered by the 62, Lord. We have the right to be there till 62. This is a situation where some of us are judicial officers who took a choice to join here. Otherwise, and we are now stuck with this situation which the government is being, should I say, Lord, difficult about.
In fact, one of the 4 members was in the judicial service. He resigned. And
But in any case, the law
Rashna was also.
that applies.
I'm sorry, Lord.
The law which was in force on the date of your appointment.
Yes, Lord.
yes,
Should hold the.
Yes, that's what. Lord,
that's
your
what
Lordship
MBA 4
said
has
that.
already held.
Lord, your Lordships has said that time and again. It's been said so many times, but somebody has to listen.
But it has been held inter partes with respect to the 4 of us in MBA 4 now.
In fact, Lord, there's a chart, if I may just point out, my learned friend, Mr. Samarveer Singh, Lord, has filed through Ms. Vanya Gupta on 7th of October. If my Lord just looks at that, that gives you the entire
Just
details.
one para.
Good.
The last para, and then if my lords could see page 485, para 116, which was said in the context of the ordinance, but applies on all 4s to this act as well. Page 485, my lords. In the
You have seen that we already marked it.
116, yes, my lords. And just one last thing is in the compilation that was given today, if my lords see the last annexure, is a detailed interim order that's been passed with respect to the 4 of us. It is my submission that that order be made absolute, my lords.
Interim order dated?
Interim order dated 6/4/2023. It is at page 246 of the compilation given today, my lords.
Order dated?
6/4/2023. It's at page 246 of the compilation.
246.
246, and the operative direction is at 252. Which considers all of this, which considers the fact that there were interim orders, final decisions, and yet the act carries forward the identical wording of the ordinance. So it is my submission, and Mr. Luthra's client would also be covered by that if this interim order is made absolute.
Mr. Luthra, the client is also in assistant.
One of the 4, one of the 4 members.
If my Lord just looks for a moment at this. Lord,
You are referring for the remaining 3.
For another 1 minute. But I, since it's the vires of the act, my lords wanted to hear first. I thought
That would be
if the
appropriate.
proviso is read down to exclude these 4 or everyone who is appointed before the act, it would actually take care of most of the ayes that have been filed today.
That's it. Ma'am,
Your Lordship, may I be on behalf of the Mumbai
Yeah,
Bar be allowed to address?
One minute,
just,
sir.
Lord, may I just take a moment and Lord just conclude this, if I may, Lord? Just have just a moment, Mr. Kaka. Just take out the IA with the IA, just let them take the IA number. If my Lord just looks at the chart, Lord, which is given by my learned friend, Mr. Samarveer Singh, and please come to page 3. Yes, but Lord, the index is this, Lord. The broad framework is pointed out. That will be at the first page. First page. This first page, Lord, that gives the details. It's been broken up, Lord, which are infructuous, where the
List of
validity
matters
is.
that can be taken up and decided.
Yes, Lord. List of matters that can be taken up and decided together. So, Lord, we are in number 2, where there are issues regarding the Tribunal Reforms Act, CGST, Finance Act, and Real Estate. Lord, that's number 2 is this. And number 3, Lord, is CSTAT. That's where we are. CSTAT and income tax are together. I'm in number 3, I'm sorry, not 2. 3. I'm in 3 now.
So the assistant members are on which?
But number 3, number 3.
3, the first part of number.
First part of number 3, not at page 3. If my Lord just turns to page 3, the
Yes.
details are there.
Page 3 the chart.
Yes, Lord. Now, if my Lord just sees, Lord, 1.2 is 1.2 and 1.3 and 1.4 are the same person.
Dinesha.
1.5 to 1.7 is the same person. My client is 1.5 to 1.7. 1.8, 1.9, same person, and 1.10, 1.11 is the same person. These are the 4 people we are concerned with. And this is on the retirement age, not that they're entitled to 62 years. And if my lord just looks at an order, if I can just show you 2 things, Lord. There is an order of 21st August 2018 in Kudrat Sandu. Ma'am, if you have my application, which is 4761, 4761 nikal denge, so the order is here. Is it here in the compilation of orders? That's what I'm just saying. Compilation of orders.
You want that? Which one is this?
1st August.
There in the compilation.
In your compilation.
It's an announcement. Sir, it's here. It's cited in, reproduced in Roger Matthews at 217 in the.
Not otherwise.
21st August is in the compilation at page 104.
Just
and that
21st August, what is it? Compilation 104. Otherwise, just take it there. Ma'am, you've got it? Hanji.
No.
Ashid, my.
Okay.
We'll go to the compilation.
Yes.
All right, bro. Compilation is there.
104.
104 mile. Case law compilation. (104) and kindly come to 106. Is your lordship at 106? 106, my lord?
Yes.
Now, please see para 2, Lord. On 16 July 2018, this court issued the following directions in regard to the age of superannuation.
Which compilation?
No, this is the case law compilation.
Judgment compilation.
Judgment compilation. Para 2, Lord, at 106. May I place it, madam? On 16 July 2018, this is just open it here. I've pressed the wrong button.
Para?
But on second paragraph, not on 16, just
On 16th, yes.
Para 3.
on 16 July 2018, this court issued the following directions in regard to age of superannuation of members of the Income Tax Appellate Tribunal. Court, at this juncture, we may note that there is some confusion with regard to the Income Tax Appellate Tribunal ITAT as regard the age of superannuation. We make it clear that the person selected as member of ITAT will continue till the age of 62 and the person holding the post of president shall continue till the age of 65, unquote. Then CSTAT, para 3. In IA 1113281, the applicant is an additional district and session judge in the state of West Bengal who has been selected as member of judicial. In CSTAT, notification of appointment of 6 officers who have been selected as member judicial, including the appellant, stipulates that they shall hold office for a period of 5 years or till attaining the age of 62, whichever is earlier in terms of the Honorable Supreme Court's order of 20th March 2018. A member of the judicial service would ordinarily have continued until the date of superannuation in the state judicial service subject to service rules. It would be manifestly inappropriate to adopt an interpretation as a result of which, upon assuming office as member judicial in CSTAT, the officer will have a tenure which will expire after 5 years if it falls prior to attaining the age of 62 years. We accordingly are of the view that the clarification issued for ITAT in the order dated 20th March 2018 needs to be reiterated. In the case of members of CSTAT, which we do, we clarify that a person selected as member of CSTAT will continue until the age of 62, while a person holding the post of president shall continue till 65. But that's the clarification we see. And it's a 3 judges combination.
Your Lordship, may I now?
For the ITAT bar.
The tribunal, Your Lordship.
That's it. I have nothing else to.
Because I filed my written submissions, Lords.
But that's all.
Hand over.
That's all I have to say.
These ones.
Your Lordship.
Well, Lord, there is one issue which I am in trouble, Your Lordship, is on Monday regarding Lord, the PMLA appellate tribunal, I just want to verify there is an order of your court, because on PMLA appellate tribunal, it seems continues to come under the Ministry of Finance, whereas they are the ones who are litigating there. That may be something which my lord we want to see. I'll just get the orders and they just take 2 minutes on Monday if necessary.
Was on the.
May I, on behalf of the Mumbai Bar,
I'm done.
Even the CAT, the same order is
issue
coming,
of
the CAT
tenure
order,
will also-
tribunal. Yes, in fact, the last bit of that order, in case of the tribunal, we clarify that the old rules provisions shall continue to apply. So therefore, that clarification, what my learned colleague is stating for others, it applies to the CAT also.
Was for the ITAT, may I
Yeah,
just
so-
point out this compilation, because had asked us to file these written note. I have Mulad's file. We'll just see a very strange situation. Sorry, you want to say something?
Can I take your lordship permission and leave, my lord?
Let me just have the list of dates.
Lord, can I take permission and leave, my lord? May I take permission and leave?
Yes, yes. Don't require that.
Your Lordship, may I be permitted on behalf of the Mumbai Bar to address whenever it's convenient to your Lordship?
I have to be back in Andhra. That's my problem. Too often there these days.
You have to be back in Andhra.
Not BC. Online.
That's
Yeah.
an advantage.
May I, on behalf of the Mumbai Bar, be permitted?
Mr. Jolly is addressing us, so.
I'm obliged.
It's an advantage.
By the way, Jolly LLB takes inspiration.
Because I would not want.
But as a person, he's very jolly and very, very bright.
I'm so grateful to my seniors. Let me just have page 1. I have tabulated the list of dates. Mr. Datar in the morning had alluded that the ITAT service rules remained from 1963 till 2017, when for the first time these were sought to be amended. Now, this is for the first time they brought in 5-year tenure. Because this was challenged in Pudrat Sandhu, then the rules of 2017 were brought in, that's 1st June 2017. It was by an interim order of 9th February 2018, and that's where I'll show the same compilation. The Mr. Luthra was reading. May just have Roger Matthews and at page 215. The same compilation, 108 Roger Matthews starts, relevant at 215. These interlocutory orders, para 72. After considering suggestions filed during course of hearing in SLP so-and-so, court passed an interim order dated on 9th February 2018. We'll just note para 1, they say that staying the composition of search cum selection committee, an interim committee was constituted. Then will see para 4 of this order. All appointments to be made in pursuance of the selection made by the interim search and selection committee shall be with the conditions of service applicable to judges of the High Court. So this was Malod's order of 9th February. And Malod's para 5, a further direction to the effect that selection made to the aforesaid interim search and selection committee and consequential appointment shall be Malod's for a term of 5 years. This was Malod's the original order of 9th February. Then Malod's will read 72.1. The Attorney General made a suggestion that please modify para 4 and 5. And what are those suggestions of the learned AG? All appointments, and I'm reading the reproduced portion at the foot of this page. All appointments to be made in pursuance of the selection made by the interim search and selection committee shall abide by the conditions of service as per the old rules. Then on para 5, further direction to the effect, all selections made by the aforesaid interim selection committee and consequential appointment of all selectees as chairman, judicial, administrative members shall be as per period provided under the old act. 72.2, the court agreed to the learned Attorney General's suggestion and made the following operative portion. Then comes a slight doubt, because what happens is on 6th July 2018, the advertisement is brought in to say it will be either as per the old rules or 5 years. There, Malod's had to then again clarify. Just see para 75 Malod's now at the bottom of that page. So in between that notification has come that we will go by as per old rules or 5 years. The following directions were also issued on 16 July 2018 with regard to age superannuation of members of ITAT. At this juncture, we may note there is some confusion, and this confusion is because of that notification. With regard to ITAT as regards age of superannuation, make it clear persons selected as members of ITAT will continue to hold till the age of 62. Well, pursuant to this interim search selection committee, I had pointed out in my opening that the recommendations were made in September 2019. And this, my lords, is also noted in, my lords, the contempt petition which was, my lords, filed by the Madras Bar Bengaluru Bar Association. Sorry?
Recommendations were made when?
My lords, recommendations were made on 21st September 2019 and put before the appointing committee on 16th October 19. And my lords, as part of the same written submissions, please see the appointment letters, which are at page 11. These are after 2 years.
Appointment committee on?
My lords, 16th October 19. Now, for 2 years, there is a hiatus. When the appointment letters comes, please see the appointment letters. Was the appointment is at page 11 of my written submission, my lords. So from September 19, the appointment comes on 11th September 21, 2 years after that. This says the appointments for a period of 4 years. But please see the table which is drawn, the names. Under the new rules where this 4-year period is coming, there is no reservation. Under the new rules today which are in vogue, there is no reservation. There are only single members. But the appointments which are made, just see unreserved category, OBC category, SC category, accountant members also, unreserved OBC, SC. So this kind of a strange hybrid sort of an appointment is made following the old rules. Search and selection committee under the old rules, when you give the appointment letter, you say 4 years. And same is for the next set of appointees on page 13. There is an unreserved category, there is an OBC category. So my respectful submission is that once the search cum selection committee had recommended under the old rules, formulating as per the old rules, the appointments had to be also as per the old rules. Now, please see one other strange situation has occurred. Just see page 14. We tabulated all the age, because under the old rules, the age, qualifying age was 35 to 50 years, whereas under the new rules, after you are disqualified if you are less than 50, because you have to be minimum 50 years of age. Now, each of these members, who was appointed on the date of the fourth column, on the date of advertisement, was less than 50 years of age. Except for one person, I must point out, serial number 8, but he was under the SC scheduled caste category. Therefore, he was given the relaxation of 2 years. Otherwise, all these members were recruited, selected, interviewed as per the old rules. There was no question of the new rules. And all of this also became clarification, and I'm done with the next 2 minutes on this. What happened? Some of the people who had applied to this as per the 2018 notification, they were not called by the interim search and selection committee. They filed petitions before the CAT. It went to the Delhi High Court. The union has filed an affidavit in the High Court in Delhi, saying all these appointments will be made as per the 1963 rules. Let's just see that writ petition I have next at page 15. They challenge the order of the CAT. The union files a writ challenging the order of the CAT that the interim search and selection committee will be guided by the rules of 1963 and will make appointments pursuant to that. Because one of the old rules, the interim search and selection committee could formulate its own procedure. Under the new rules, it's a proper procedure is laid down. Now, please see this writ petition, my lords, which I have set out. And please see the government, my lords, at page 5 of this writ petition by the union. No, sorry, the running page 22. I'm so sorry, my lords. Running page 22 of this written submission. And this even was the last para on this page. It is submitted that the Income Tax Appellate Tribunal members recruitment rules 1963 regulate the recruitment and conditions of service of persons appointed as president, vice president, and members of ITAT. It is submitted rule 4 of the ITAT member rules provides selection board is well within its right to and powers to evolve its own selection procedure. In light of the above, interim search and selection committee met on 1/5/2019 to deliberate and evolve the process of selection of members of ITAT. It was decided by the interim search and selection committee, applications complete in all respect received on so-and-so shall only be considered. So what the union stand was that pursuant to the 6th July 18 advertisement, all appointments will be made as per the old rules. We are not bothered by the new rules. And today, Manoj, when the appointment letters are issued to the same people who were part of that process, the 4-year period is introduced. And therefore, I'll conclude with this. My respectful submission is that members of the bar, and therefore we are here. Young members of the bar at 35, 36, 37 applied pursuant to the advertisement which came out and pursuant to the order of this honorable court and the suggestion of the learned attorney general that we'll go by the old rules. When their appointment comes 2 years later, they are given this letter of 4 years. And those, as Mr. Lord referred to the judgment in Narendra Singh, that will apply in all force to the ITAT. Because for CESTAT, following the ITAT, they've been given that benefit, but our benefit has been taken away. That is my respect.
They have also not been given the benefit.
In fact, allowed to continue after 4 years as part of interim orders by my lords. The members of the ITAT, which were appointed in 2021, are bound to retire in December 25 now. And a suggestion was made by the learned attorney general that there is reappointment. So there is what is the loss? What is the reappointment? It's 2 years.
All of you participated in the selection process of 2019.
Sorry, Manoj?
All of you participated in the selection process of 2019.
18 Manoj. Process began in 18. And the 18 process finished in 21, 3 years. The 23 process started, which finished, was 22 process started, which finished in 24. So it takes minimum of 2 years for them to complete the process. Now, if people are retiring in December, they've not even initiated the process for reappointment. Will be 21 members of the tribunal will be out in December, and who were assured that they will have age of superannuation of 62 years. Therefore, our respectful submission is they should be given the benefit of the orders in Kudrat Sandhu and Roger Matthew.
I just point out what the Rani colleague said again squarely applies to CAT member also.
One statement I conclude, I am for the same members of ITAT. Just one other date I want to give to your lordships. I was not here, perhaps my friend has given.
But you are in that group of 21 or?
20.
ITAT. What my friend has argued. 21st September 2019, our recommendations were forwarded to the ministry.
That he has already given.
He has given. That's all. That's all. Though we are completely covered by the bill.
That is the false date that he gave.
Not same applies to the CAT also, my lord.
Let the income tax tribunal be over. Mr. Kaka wants to, I think.
Yes.
I'm obliged, Your Lordship. Your Lordship, just 2 things I wish to support. Firstly, I think on what is to be done with those who have been appointed while this litigation has been pending. My colleagues have argued that the court's interim orders have to be protected. I also want to show you that even there is an additional way which the Supreme Court has done, both in MB3 and in MB4, and that is in the final orders and in Roger Matthews, that all appointments made pending this dispute will be governed by the Parent Acts, and that itself will take care of all the IAs currently. And if your lordship will just turn to MB3 first, come to page number of the compilation that my learned senior Mr. Datar filed. Come to page 272 first. This is the starting point of Justice Nageshwar Rao's judgment. Now come to placitum D, if your lordships will see on page 272. Does your lordship have placitum D? Yes.
I think 272 is Roger Matthew, perhaps.
Yes.
No, 272 is Roger Matthews, not MBA.
This is, sorry, your lordship, this is of, my mistake. Yes. No, this is Justice Nagesh. I'm in the wrong compilation, your lordship. If your lordships will see the compilation of in MB3, which is, my apologies, page 363. My apologies. This was in another page 363. It is the same judgment, but another page. Now come to placitum D. In MB3, they make it very clear that they are only applying the constitutional bench, and this judgment has to be read with Roger Matthew. This takes care of two arguments, your lordship. Firstly, the argument on what happens to those who have been appointed during the disputed time, because Roger Matthews, as my colleague Mr. Jolly read out, has the interim orders which protects the ITAT members which were appointed in 2018 in the final judgment. Secondly, the larger argument of the learned Attorney General that there is any challenge or requirement to refer it to a 5-member bench also doesn't arise, because these are only interpreting what a 5-member bench has already decided. Coming to the point that I am now arguing, which is what do you do with those who have been appointed while these disputes are pending? All the benches of the court so far, Roger Matthews, MB3 and MB4, have protected them under their old parent statutes. In MB3, the relevant part your lordship will find at page 388 of this same compilation. It starts from the last line of page 387. The appointments made, does your lordships have it? The appointments made during the pendency of Roger Matthews, on the date of the interim orders passed therein, and appointments made after the judgment of Roger Matthews, like the appointments made prior to 2000, are no doubt to be governed by the then existing parents' statutes and acts and rules. In view of the interim orders passed by this court, appointments made during the pendency of the case in this court are also to be governed by the Parent Act and rules. If your lordships incorporates this, it will take care of most of the applications. Because those who have been appointed...
But then this judgment upheld the tenure of 5 years.
I'm coming to the tenure in the immediately next point. Right now, we are only dealing with the issue of
future appointments.
If I may,
those not yet appointed would
may
be
I
covered by the
request my
5-year
learned
tenure.
friend?
Those already appointed was safe.
No, already appointed.
May I
during the
request my
pendency of
learned
Madras
friend
Bar.
to allow me to
My
submit
lord, see,
and not
read
interrupt
4.
me.
This is again reiterated.
We are right now
Paragraph
only dealing, Your
115, my
Lordship,
lords.
I will
This
come
is
to the tenure
Butts.
of 5 years
Yeah, good.
later. We are only dealing with those appointments that have been pending during this interim period while this dispute. We will come to the 5 years in a
Next page,
deal
para
with.
60.10.
Yes, I will
60.10
deal with
onwards,
that.
if you just.
I will deal with that immediately, but I'm only right now on the part of those who have been appointed while this dispute. So either you protect them by upholding the interim orders, or you pass an order like has been done in
2020 rules shall have prospective effects and will be applicable from 12/2/2020. That's the most,
Absolutely.
all the appointments made prior to 2020 will be protected. At the
Correct.
most, not during the pendency, not between 20 to 25.
Because please see the last line, Your Lordship. In that same paragraph 59. Right now, we are dealing with the Statute of 21. If your lordships holds it to be unconstitutional, all I'm requesting is that the protection to those who have been appointed during this time be the same as is done in MB3, MB4 and Roger Matthew. That is all that I'm saying. Now come to MB4 in a minute and you will see the same.
Not be in conflict with the larger bench when the 3 judges bench says that the 2020 rules shall have prospective effect and will be applicable from 12/2/2020.
Yes,
As per
but
rule 1/2 of the. But if
please see
we
the last line. Again, please see the last line, Your Lordship, subject to the modifications directed in the preceding paragraphs. So when you read this entire paragraph, those who are protected by the interim orders will continue to be protected.
Where is subject to modification?
Subject to the modification directed in the if I may read 59 again. May I just read 59, Your Lordship? As we have held that the 2020 rules are not prospective, the point remains to be decided the applicable rules for appointment that were made prior to the 2020 rules. Now come to the part, because there are 3 buckets. Those who are appointed during the dispute, those who are appointed after the rules that have been assigned, subject to the modifications of this paragraph, and those who will be appointed prospectively. We are dealing with the situation of people who have been appointed in 2018 under an interim order of this court, which Mr. Jolly read out, and protected by this order.
If you are concerned with 2020, then there is no issue that is already covered by Mr. Jolly's arguments and
Very
Mr.
well. I will leave it at that.
The question is whether we can enhance it even after 2020, after the judgment of Madras Bar Association.
So, Your Lordship, my thing is only that those whose appointment process is completed by the period of 2020 will be governed by the Parent Act and rules. Now I come to this.
That has been very jollily argued by Mr. Jolly.
Very well. So I'm only pointing out that what was, I don't want to repeat. Just come to MB4 for a minute, Your Lordship. Just for a minute, come to page number 60, page number 457. Same protection granted under paragraph 65, and I leave it at that. The interim orders of Kudrat Sandhu are protected. That is all that I am repeating in the final orders itself. Yes, Your Lordship. 457, page paragraph 65. This is of MB4. And this refers to the interim order on the tribunal itself dated 16 July 2018.
Yes.
Yes, I now come to the second issue, which I wish to extend my learned senior Mr. Datta's argument on what should be the tenure. We have now a situation where the tenure is put at 4 years plus eligible to be reappointed, not a right of reappointment. I want to deal with that. If your lordships will come to paragraph 66.1 of Mr. Datta's submissions, I wish to expand on that.
So what does the Madras Bar Association 4 hold with regard to the tenure?
That holds that 4 years is also unconstitutional. Since your lordship has asked me that question, let's come directly to that paragraph. Come to page 456 of the compilation.
Yes.
Remember in Roger Matthews, your lordship, just a little bit of history. Roger Matthews is the 5-judge bench that holds 3 years to be too short. MB4 holds 4 years to be unconstitutional. We are again with the situation of 4 years today. And that, since your lordship asked, the Chief Justice asked me, see page 456, placitum F for father.
Yes, but then if Roger Matthew directs that 3 years should be increased to 5.
Yes, 3 years actually, your lordship, the 5 really comes in slightly differently. Roger Matthews, with respects, if you will see, 3 years comes really in the 2021, which is the MB3. I'll come to that in a minute, but Roger Matthews, since your lordship wants to go, please come to what was in Roger Matthews. Come to page 247. What were the tenure issues in Roger Matthews? 247 of this very compilation. Roger Matthews was not an issue of 5 years. Roger Matthews was an issue of 3 years. On page 247, placitum C, which is the term of office, it refers to Schedule 5, and that schedule refers to only 3 years. And where will you get that? In Roger Matthews itself, at page 262 of the compilation. And this is the paragraph which I wish to highlight when your lordships are now considering what should be a tenure. Come to page 170, paragraph 171 at page 262. This is what was before Roger Matthew. Another oddity which was brought to our notice, does the Chief Honorable Bench have it? Is that there has been an imposition of a short tenure of 3 years for the members of the tribunals as enumerated in the schedule of the tribunal rules. Now see, this is the ratio which I respectfully submit should be relevant. A short tenure coupled with the provision of routine suspensions pending inquiry, lack of immunity thereof increases the influence and control of the executive, thus adversely affecting the impartiality of the tribunals. Furthermore, prescribing such short tenures precludes cultivation of the adjudicatory experience and is injurious to the efficacy of the tribunals. I wish to pause just for a minute, just to give you a little context, your lordship. I'm, of course, from the chambers of Mr. Dastur. My father, Chief Justice Gavai, will know is from the chambers of Mr. Palkhiwala. The Income Tax Tribunal has been there since 1961. Today, it decides matters not only of domestic tax law, but also of international tax matters. It has received recognition globally, and since 2002 also decides transfer pricing. Transfer pricing is a combination of economics and law. These take time to be developed, the adjudicatory skills. And let me give you an example that's happening as we argue this matter. On the 28th of October, my AOR is in the courtroom at this time. Total of 16 members have been appointed to the tribunal while this hearing is taking place. 20 members are being forced to retire at the end of December. Even if they have completed their 4 years and they go back into this process, what happens to their experience? What happens to their seniority? What happens to the tribunal?
Where does Roger Matthew direct modification that the tenure should be made 5 years?
If your lordships will see, I'll continue to read. Therefore, just see paragraph 172 again. I'll come to where 5 years is there. Your lordship will see 5 years comes on page 380. And that is not Roger Matthews. So I'll come to it in a minute. But let me just complete paragraph 170, the relevant part of Roger Matthews. Please see, because ultimately this is what guides you. 171, 172, 173 and 174, which will guide you with respect, is my submission in Roger Matthews. Let me read 172. I'm back at page 262. This court, this court criticized the imposition of short tenures of the tribunal.
That's what even at the other paragraphs, at page 281.
I'm obliged. Lord.
They say that the rule should be so modified that it should provide an assured tenure. So therefore, we want to find out as to where this 5 years has been written.
Yes, therefore I submit Roger Matthews is an assured tenure. That is what guides you. And consider those paragraphs and consider the history of the tribunal. This is a tribunal that has been there since 1961. It has done well. It has served India well, both within and outside the countries. Foreign investors rely on it. As I said, I agree with my learned senior, Mr. Dattar. This is not an adversarial issue. We are protecting the institution. Roger Matthews says these kind of tenures will only damage, and the damage will be across the board on seniority. Now, today, just consider those who are appointed in October, just 3 days ago. What will happen to those when they sit with the senior members in January? Who will be the senior member? Because they have to go through the process of eligible reappointment. I have, with respect, not only spoken to the existing members of the tribunal, but even the president before addressing you. The chaos that will be caused to this institution by these kind of a contractual judiciary will destroy the institution. And what is the argument of the learned Attorney General? Allow this to continue. What will continue? You have 4 judgments of the Supreme Court saying you cannot do this. So the government will say, allow us to be in contempt and see what will happen to the course of law. How can this argument be stated? And may I request you, so therefore let me complete on this 5 years tenure, Your Lordship. Let me complete my submissions.
So permit us to make one query if you...
I'm sorry.
So from where does Madras Bar Association get that the Roger Matthews directed modification that the tenure should be 5 years?
So, Your Lordship, my submission with respect is that comes much later, and that, as I pointed out, is in much later in MB. This is the 2021 judgment, and that you will find at page 380, paragraph 41.
224.
Yes. Actually, the relevant part of 5 years comes in page 380, placetum C.
Should be before. That's the fourth.
Does your lordship have page 380? Now see placetum C.
Page 380.
380.
It's 370.
the rules which were in existence prior to 2017,
Yes.
so far as income tax tribunal is concerned, there was no tenure appointment. It was up to the age of 62. If I'm not wrong.
Absolutely. Your Lordship is right. Prior to 2017, it was up till the age of 62.
Madras Bar Association, which says that
The contractual appointments came in 2017 only. Or the contract.
Madras Bar Association, which says that Roger Matthews provided that the union should do modification and put up a term of 5 years, then that does not correctly.
With respect, I would submit this part of MB 3 and 4 requires to be read differently. It can be at the highest and obiter. The obiter, the ratio is Roger Matthew, which is contractual tenure should be avoided. And therefore, it should be the 62 years has served this country. Therefore, my submission is it should be, and the question of 4 years doesn't arise in any situation.
Because 173, 174 suggests that. It says you can't have short tenure, therefore please have a relook at your rules.
No, that's what. Relook, but then,
may be modification.
But then 3 to 4 and 4 to 5 hardly makes any difference.
No, on the 3, 4, 5, I'm not able to find.
I'm absolutely grateful to the Chief Justice. It makes no difference.
If a person after 5 years of tenure
Correct.
has to seek his renomination,
Absolutely.
where is the question of independence of judiciary?
No, absolutely.
Yeah, he will
Completely.
be-
All of them.
he will be looking forward to his renewal. Then
Yes, no, completely. Absolutely.
And Chief Justice, please consider this, the finance.
62 years.
62, that's
And it was said assured period.
Yeah.
So that does not mean that it was limited to 5 years.
No. Only there are.
so there was the 62. So MB 3 and 4, they wrongly read that Roger Matthew holds that the tenure should be 5 years.
No, yes.
Because at Roger Matthews, it was 3 years, like Mr. Kaka said. Then it was amended to bring in 4 years. In MBA 3 and 4, 4 years was struck down to say that is short. But the court didn't say that Roger Matthews had propounded 5.
So that's what was read.
That is exactly what I'm submitting, Your Lordship, is to be guided by Roger Matthews. And therefore, the tenure.
General, that it should be, the suggestion came from the Attorney General that we will appoint for 4 years with a compulsory reappointment. So MBA 3 records that in para 45 that it will be compulsory 4 plus 4 and it becomes 8 years, minimum of 8 years. After MBA 3 was pronounced, then a clarification was sought saying make it preferably reappointed. So that was also taken away. But Roger Matthews never said 5 years or 4 years. Roger Matthews said 3 years is not correct. So that's where it.
And assured.
I'm so. Therefore, I request Your Lordship, paragraph 170 of Roger Matthews is what guides you till 174. And what was the tenured service? Has served the institution well. What will happen with a contractual service will damage this institution rapidly. And please consider
prior to those appointed insofar as those appointed prior to 12/2/2020, then it will be squarely covered by Madras Bar Association 3. They will be governed squarely by the old the parent statute.
Your Lordship, I submit two things. One is that those who are protected by an interim order during the time of appointment, even if their appointment is delayed, because the 20 members of the that is argued very well. I won't repeat that. If Your Lordship is with me, I'm sorry. I thought Your Lordship was questioning that.
No.
That is out. But if Your Lordship holds these rules for any reason, or the Act and the tenures to be contrary to the Constitution bench in Roger Matthews, I submit Your Lordship has the power to implement what was guided by Roger Matthews and go back, because we don't have the reasons. for a contractual judiciary. We don't have what was a tenured system is to be changed. And therefore, what was working, we have no reasons to substitute it. And remember, the tax department or the Ministry of Finance is always a litigant in the tribunal. And this same litigant will indirectly in some way be connected every 4 years with the appointment of a judge. It's unconstitutional to state that. The damage that will be tremendous to this institution. I'm grateful for this hearing.
Thank you, Mr.
Lord, just to indicate, these members, 21 members are already before your lordship. Their names and their MA numbers are mentioned in the chart at 15 and item 18.
We did not go into that. We only said that those of, if we, in the event we are with you.
In the event. Well, if your lordship will take up that index to that chart which Mr. Luthra had handed up.
Your Lordship, may I complete with only one submission? I do not ever wish to give the bench, which I know is preoccupied with so many matters, but if you have only 20 minutes over this weekend, log into the Bombay Bar Association. The most respected person today in India, Mr. Dastur, has given a podcast on what will happen with this act on the tribunal. If your Lordships has just 15 minutes, I bear with me and see it. I close with that.
We will be, if we do that, we will be alleged that we are referring to an material which is not put to the other side.
But I'm asking the learned Attorney General, this is not an adversarial litigation. I'm requesting him to see it also. I'm requesting the AG to see it also. I'm grateful, Your Lordship.
How many podcasts have been done so far now?
Your Lordship, there are many being done. There are many, I think about 8 to 10 have been done, and they have been a tremendous hit. So I'm grateful to the Bar Association because we are fortunate to have the wisdom of so many of these seniors saved for posterity.
Thank you. Thank you.
I'm obliged.
I suspect the day is not far away when my Lord, the Chief Justice, will also be a part of that podcast.
I'm in the waiting list, number one.
You're waiting list. I had a feeling.
I've been already told by Mr. Nitin Thakkar that in my next visit to Mumbai.
We'll all look forward to it. Manoj, if you just see the index to this chart, there's slightly different aspect.
Last one was Justice Oak.
Yes. This chart encapsulates one of the various categories. If you just see category 7, I'm on the cherry picking issue in the index, which is the first page, page 1. What has happened, Manoj, is this, and you'll see the IA is dealt with at pages 15 and 16. The first two items there are contempt petitions, those you can ignore. The rest, which are 11.2 through 11.7 at page 15, 16, you'll find only up to 11.5. 11.6 and 7, we have given on one additional sheet, Manoj. There's a separate single sheet in which we have mentioned about 11.6 and 7. Effectively, there are 4 individuals who are affected by how the actual appointment has taken place. So it's an allied issue. We'll abide by whatever happens on the constitutionality issue. And the facts simply are these. This is dealing with the advertisement that was issued for the ITAT members on 6th July 2018. Now, if your Lordship saw in Madras Bar Association 4, when Mr. Ninad Laudu was reading that paragraph, there was a reference to this advertisement. Now, what took place sequentially is, first there's in that Kudrat Sandhu's case on 9th February 2018, there's an interim order passed by the court. And the court says that for all tribunals, the selections will now be by the search cum selection committee, which would be appointed head by a judge of the Supreme Court. And that it will be governed by the old acts and rules. So we are governed by the 1963 Act with that tenure of 62. I am appearing, my lords, in 11.6 and 7 for an administrative member. The other applications, I'm not appearing there, but those are judicial members. All 11.7? 11.7 is also judicial from what I understand. So On 9th February, interim order passed. Those interim orders would apply to us, and the advertisement is issued on 6th July 2018. After the advertisement is issued, in September 2019, this search cum selection committee makes its recommendations. I'll just trouble your lordships to see that one page in the IA that we have filed. The minutes we received much later by RTI only in 2024. IA 272629. Over, yes. The redacted minutes were shared with us in RTI. And if your lordships can come just directly to page 50. 50, page 50. This part of the redacted minutes, I'm not reading less, but I'm taking you directly to the accountant members list. My lords have that list of 10 names, which are the unreserved list. Just see page 52, which is the wait list there. Now, in that wait list, there are two issues here. In the wait list at page 52, the first name is Rohit Kapoor, which is me, 11.6. Right now? I'm not appointed, despite me getting 68. Serial number 4 there, Arun Khodpia, who's got 63 out of 100, is appointed. They have not followed the process at all. There's absolutely no reason why a person who's 3 levels below should have been appointed. Second, and I'm 8 years younger as well. So that makes a massive difference. I was around 39 or so when I had appointed. My date of birth, you can see there. It's 1980 in comparison to the other gentleman, 1972. The second is at page 50, back on the main list of the 10 names. If you see number 8, Rakesh Kumar Lodha. Rakesh Kumar Lodha is a gentleman against whom there was an IB report which raised questions, so they didn't appoint him. However, now, after a subsequent advertisement in 2022 for a later round, they've appointed him, which of course doesn't affect me directly, but it raises questions about the process. Because if there is an IB problem and there are 3 people on this list of 10 who were not appointed, but they're appointed later. When there is that IB question, I'm surprised if the IB question went away, but that's taken place. Now, our primary issue is the fact that there appears to be cherry picking in having done this. If you see, and this is why I want to just tell you lordship the status as it is now. Give copies of the chart. It's been given. Give me a copy. This is the status as things stand today within the IT80. Start copy. Out of this very advertisement, just on this advertisement.
Get a copy?
Yeah, thank you. Give it to the computer.
Thank you.
This is the total vacancies advertised by the circular. You'll find unreserved. Accountant members are 10. Now, if I skip to serial number 2, of those recommended, my lords, 10 of the unreserved were recommended and 5 from the wait list. If you come to serial number 3, approved by the Appointments Committee of Cabinet, there's unreserved 6 only were recommended because others had that IB issue against them. And on the totally that takes it to 8. And in wait list, there's 1 on page 2. 1 from the unreserved. Now that's where they went to serial number 4 when they should have come to me. I'm serial number 1 on the wait list. So that's where the leap happened, and I don't know why that happened. And then if you come to serial number 4, this appointment takes place in 2021. In 2021, September 2021. The appointment has 5 from the unreserved main list and 1 from the unreserved waiting list. So only 6 out of the total vacancies that they had of 10 unreserved, which they had advertised. So right now, there are 4 unreserved remaining vacancies. The reason I say this is because that gentleman who's number 4 on the wait list, in fairness, he's not a party here. So I would have had to make him a party if at all any of my arguments were to dislodge him. I'm saying because you have those 4 vacancies still existing from this 2018, which is a fact which is noted in Madras Bar Association 4, saying, following Roger Matthew, following MBA 3, saying that the old acts and rules will apply. The process has to follow that. If the process has to follow that, and there is a specific reference at para 55 of Madras Bar Association 4 to this very advertisement, this 2018 advertisement, and saying that we remain protected by the interim orders. That being so, my lords, I only seek that this cherry picking should not have happened. Today you have the vacancies, and that that 11.6, I should be accommodated against that. I'm grateful.
No, but what do they say? Why they did not appoint you? What is their reply?
We don't know, my lord. There's been no response. No clarification. No reason has been given. Even in the minutes, there's nothing recorded. This is contrary to the recommendation made by the committee. Once a committee gives a particular order, there was no question of any discretion available to them to go further. You have to go by this recommendation, otherwise you have to send it back to the committee. Because even seniority would follow this, my lords. And I would lose out on that.
Yes, Ms. Suhasini, you have to find out as to why he was not appointed.
AG will address on this specific.
No, but then on facts, you will have to find out from the department as to why.
Lords, in the same breath, 2 minutes only I want to say, my lords. Your lords were holding this compilation. My learned senior friend showed page 50. Would your lords oblige us by having page 48 of that same document, lords? I am for 3 people. In fact, Mr. Gopal's client is in the wait list. My lords, we were recommended by your lordships committee, my lords, in the main list. Of the same selection, everything is the same, lords. Please see page 48. Same document, lords. And please come to page 49. 49 lordship sees, my lords. At the top, do your lordships have serial for Devinder Kumar?
What is the name of your client, Mr. Chandran?
Mine is Rohit Kapoor, my lords, in the accountant list. In the accountant wait list, page 52, first item. Rohit Kapoor.
So the 3 we are representing, my lords, are for judicial members.
Yes.
In the main list, not even in the waiting list, my lord, who were recommended by the committee. Page 49, lordship sees serial 4 is Devinder Kumar.
One minute.
I'm sorry.
Mine is accountant.
What is the name of your client? Devinder Singh.
Serial 4 is Devinder Kumar. Serial 8 is Sheetal Borkar. These are in the unreserved category, my lords.
Serial number 11.4 and 11.5.
The IAs, if your lordships are saying, 11.2 to 11.5, lords, in the white and blue chart.
Yes. Your matter is 11.2 to 11.5.
Yes, my lords, in this white and blue chart. Yes, my lord. And we are, my lords, Devinder Kumar and Sheetal Borkar in the unreserved category. They were in the main list, my lord. Devinder Kumar. Page 49, serial 4 at the top, lords will find. The second entry, my lords, serial 4, Devinder Kumar. Then serial 8 is Sheetal S. Borkar. And the third applicant is below the page, lords. In the SC category, lords will find, lords, the last name, Mr. Sudesh Kumar. Now, all these 3 lords were in the main list for judicial members. By passing them, lords, they went to the wait list. That issue was touched, lords, in 2022, 12 SCC 802, which has been read out to your lords by our senior friend, Mr. Datar, lords, in the morning. But, lords, subsequent to that, they only gave names of 6 lords, candidates in this process against whom they said that there were allegations. We are not the ones, lords, in those 6. So they gave those 6 names to the Honorable Committee, lords, and the Honorable Committee on 8/6/22 closed it by saying that you should have given to us earlier. We feel helpless. So our names and our reasons were still not given to the committee, lords. So this is where we stand even today. And we are praying to your lordships, lord, that we were in the select list at that time. We may be, lords, considered for appointment as member judicial.
Well, with your lordship's permission,
So the material against you was given to the search committee.
There was no, we were not in the tainted list, my lords. There were 6 more. So pursuant to your lordship's judgment, my lords, where the contempt was converted to MA, they were told that you give, why you have not selected, give to the committee. So they gave names of only those 6 my lords against whom there were allegations. We are not the ones against whom there were allegations. We were bypassed without any allegations. No reasons has come forward, my lords, till today as to why, my lords, we were not put in the appointment.
And I'm sorry, just to supplement that in the final appointment list of 22, we find names which are not in the search cum selection committee's recommendations at all. They're parachuted in from somewhere. There's one Ganyash Dattatray Padmashali, accountant member, who's at serial number 19 of the appointment which took place on 15 July 22. His name is nowhere.
Yes.
Well, let's with your lordship's query
Very
with
deeply
regard to
obliged.
Roger Matthew, where in Roger Matthew, the 5-year is actually stated. If lordships have a look at para 172, that's where para 168 onwards, the tenure discussion starts. At para 172, the bench there relied on MBA 1, that is the 2010 judgment, where at para 120, sub para 9, this court said, held that either it should be 5 years or 7 years following the Sampath Kumar rule. If lordships may have para 172 of Roger Matthew, which is at page 262.
Yes, a tenure of 3 years may be suitable for a retired judge of the High Court or a Supreme Court, or even in case of a judicial officer on deputation. However, it will be illegal to exercise so and so. Forgo is well established practice, sir, as a member. Where do you get that 5 to? It's not there in para 72.
172, if lordships visit this court.
I'm at 172.
172 of Roger Matthew. This court criticized. This court criticized the imposition of short tenures of the members of the tribunals in Union of India versus Madras Bar Association 2010, and a longer tenure was recommended. If we see 2010 at para 120 sub para 9, this court said it should be either 5 years or 7 years.
Well, I'm appearing in 11.7, identical.
In fact, lordships may have, I'm grateful to my friend, even at para 171, where they start the discussion that another oddity which was brought to our notice is that there has been an imposition of short tenure of 3 years for the members of the tribunals as enumerated in schedule of the tribunals rules 2017. So in fact, in MBA 1, while MBA 1, the same point was being discussed, there also at para 120 sub para 9, this court said the tenure should be 5 years or 7 years, being a longer tenure and a fixed tenure. That is actually taken from a principle laid in Sampath Kumar also, where they said that tenure generally should be between 5 to 7 years. So that's how, even in MBA 3 and 4, wherever this discussion has happened, both the bench relied on both Roger Matthew and MBA 1 for holding 5 years as a suitable tenure.
MBA 1 is also placed on record here?
Yeah, MBA 1 is also there in the same compilation at page 37, and para 120 sub para 9 is sub para 9 is at page 102. If lordships have page 102 sub para 9, the term of office of 3 years shall be changed to a term of 7 or 5 years, subject to eligibility for appointment of 1 or more term. This is because considerable time is required to achieve the expertise in the field concerned. A term of 3 years is very short. By the time members achieve the required knowledge, expertise, and efficiency, 1 term will be over. And further, the set term of 3 years with the retirement age of 65 years is perceived to have been tailor-made for persons who have retired for a shortly to retire, or encourage these tribunals to be treated as a post-retire.
It should be 5 to 7 years.
In the same, if I read it further,
the tenure should be longer.
Right in the beginning, the term of the office of 3 years shall be changed to a term of 7 or 5 years, subject to eligibility for appointment for 1 more term. So effectively, anyone would get between 10 years to 14 years.
Then we are bound by this. So 5 judges.
My lords, may allow me 11.
I just wanted to give that.
Thank you. 11.7 in the category of cherry picking, category what sir just argued. 11.7, I'm appearing for the applicant. Identical facts, I was waitlist number 4 and someone who was appointed below me has been appointed as a judicial member. That's the factual part.
You are it. What is your good name?
My lords, the name of the applicant is
No, you have good name.
Naman Tandon.
Naman Tandon.
Yes, my lords. The IE number is 27305.
Give us the item number.
This is 11.7 of the chart. The applicant name is Anand Kumar Pandey. He was appointed, he is there in the wait list at unreserved category of judicial member at serial number 4. Page 53 of the 11.6 IE, my lords. And my lords, if on the final appointment list, a candidate who was ranked below me has been appointed as a judicial member.
What is that? What is the serial number?
Of the appointed candidate? Yes. Anubhav Sharma, which is at serial number 5 of the waiting list.
Immediately after you.
Yes.
Page 53, that table.
So I you just note all this.
I'm obliged.
Gives one page chart of the appointment, it's now. But I put a question mark. Yeah, this one. I put a question mark in that person. It's not there in the minutes at all. It should create a committee. If the name should emanate from the committee without coming from the committee, how could they have appointed a committee?
Just one clarification was there was this less confusion like that's what I had contended was that all the process which had begun from 2018 was protected by the interim order. That's
that you are.
It's not just the consequential point because the interim order said these
So even the learned attorney made a statement that during the interim there shall be temporary search and selection committee and the appointment should be made on the basis of the.
The suggestion was that selection and the consequential appointment. So if the selection is as per the old rules, the consequential appointment will not be as per new rules. That's the problem.
My lords, if I may, there's also one more IA which was not within the compilation of the nodal council.
It was filed subsequently.
It was filed subsequently. It was not in the compilation of the nodal council. Well, it was basically about that the appointment was delayed by around a year. The process started in 22 and the appointment could only take place in 24. So what happens is, my lords, 3 of the judicial members in that period are now aging out. So that was the only contention that their tenure should be.
Aging out means?
My lords, they were attaining the age of 67.
So you want to continue after 67?
My lords, all I'm saying is that the time period in which the appointment should have been done.
That should be extended.
That should be extended, my lords.
Okay.
That's only.
Great. Rejected. Rejected.
I have filed an ID for serving ITAT member. I have filed an ID for a serving ITAT member in writ petition 09. It's regarding the promotions.
The promotion and all that we are not going to do.
Plus, that's the issue that Mr. Balbir Singh had already addressed.
Plus, may I have your lordships?
I'm hoping we won't see an MBA 6 after.
We don't know. Fortunately, I will not be there.
Have your lordships.
At least I should. I have to start working on the judgment before the learned AG.
May I have your lordships leave to mention item 28? Plus, with great difficulty, it came on board last week. Your lordships had kept it today. Can it be rolled over to next Friday? Item 28.
What is it about?
This concerns an industrial estate in Madhya Pradesh. There's a stay order operating against, as your lordship said, your lordships will look into it and dispose it of. It came last week, plus after mentioning. From last week, it has come today, plus your lordships roll it over.
We will skip next Friday.
If it reaches, we'll take our luck. We'll try.
After next Friday.
No, I understand. That's why we'll try. We'll try.
So Gopal Shankar, and we are trying to reconsider that those issues. Rajnish. So we are putting it for hearing again. Not detrimental to you. Well, in one case, detrimental to him. No, he'll get it.
Find a way when it's not detrimental.
No, because what is speaking yesterday was those review petitions which were filed till particular date, they were rejected. And all review petitions which were heard by the other bench, they were entered. It's entered and interim orders also passed. It's
Must be some way to reconcile it because
it's a very fortunate circumstance that for particular persons, IA comes before somebody retires. Only insofar as those limited, we are not going to entertain those who are coming now. Only those who had filed review petitions and they were rejected. Because they have no other option than to file an IA.
So even interim order saying review petition.
No, not review petition. We had dismissed all IAs also yesterday.
I understand.
No, but there are certain IAs which was noticed by me yesterday that all review applications which were listed before a particular date.
Okay.
I don't want to.
Yeah, very well. No.
So they were rejected, and the other review applications which came before another bench, they were entertained. So, but what happens to them because they took request to order remedy available to them because of fortuitous circumstances. Yeah.
We've seen the same thing happen with those land acquisition matters, the 24/2.
Yeah, 24/2, yes.
Before or after a date, before.
No, if we went before particular benches, it was those review petitions were allowed. At least insofar as which came out before us, we had said that the inter parties of matter stands concluded, and therefore we are not entertaining the review.
EAs were filed where reviews were dismissed, and they were taken up along with review petitions, and then a common principle had to be drawn out.
Yeah, because
whatever the best.
Otherwise, we have to try to do something. Otherwise, it will lead to.
No.
So maybe Tuesday or Wednesday we'll have to. So we'll have to cut down on your Tuesday or Wednesday matters.
Suggestion, Manoj, is for that matter, if you can appoint an amicus or so, it may help that somebody goes through everything neutral, who has not appeared on either side, and then they can give.
But who can do it on such a short period?
Those towards the end of this, Mr. Hasni, Mr. Parmeshwar, they're all in.
So Mr. Parmeshwar would be totally busy on Monday, Tuesday, and Wednesday with.
How he and Gaurav
You have something against him. Yes, would you be?
Chandran.
Who?
No,
Yes.
No, you just have to find out. The party is not on board today, but just try to find out those IAs.
Yes,
We can. I have already asked the court master if you can assist him.
I will do that, my lords.
Only such cases where IAs were already filed.
Yes.
Sorry, review applications were filed.
Yes.
And they were rejected.
Very well.
Yes. And those persons then thereafter file IAs immediately.
Very well.
After that, they came to know that referred to a larger bench.
I'll do that exercise.
Formal appointment will make it on.
My lords, not necessary. It's not necessary.
So if we take up that matters on Tuesday or Wednesday.
Then may I then pray that your lordships only list 2 or 3 fresh IAS pilots, fresh IAS and the Corbett and Aravali, because anything after that may become superfluous.
No, because I have to write also.
So there are 2 or 3 small fresh.
So Corbett, my judgment is almost ready, except because I thought that we must give an opportunity of hearing to the state of Uttarakhand.
Today, just if your lordships permits me, Milords, then only those 2, 3 fresh IAS, Corbett and Aravalis can be listed.
Whatever can be done in one day. No, Aravalis will have to. Aravali is that common definition.
That we can do. So Corbett, Aravalis, and the 2, 3 fresh IAS. The rest we'll just roll it over to the next month. So we'll do that. I'll inform the list. Great.
you